So yeah, 74%, or that big blue area, were settled. That is by far the most likely outcome in 2019, was a settlement of an employment litigation case. The second largest category was the orange category, which is 12% of the employment cases ended in some kind of procedural resolution. For example, the case was dismissed potentially because it was resolved in another venue, like in arbitration, that the parties had agreed to at the inception of the employment relationship. So the areas that we're going to focus on today, however, are the gray and the yellow areas. Those are where the case was what we call litigated to judgment. That is, at the end of the litigation, either the plaintiff or the defendant prevail based on a decision by the judge or the jury. So that's what we're going to focus on for the results of 2019. And the fifth most common outcome in 2019 was there were 361 findings of no ADA discrimination in 2019. 98% of those cases were results for the employer. Only 2% were for the plaintiff employees. Now, the number 4 most common case is quite different. This is violations of the Fair Labor Standards Act, most typically unpaid overtime. In those cases, in 74% of the cases, a judge or a jury found on behalf of the employee, and only 26% of the time did the employer prevail in those kind of cases. So just a spoiler alert with regard to all the other ones, this is the only employment category where in federal cases where the plaintiffs prevailed more often than the employer defendants prevailed. So the data here clearly speaks for itself. It demonstrates that employers are vulnerable to FLSA claims, and they're more vulnerable to those than any other kind of employment lawsuit. The number 3rd most likely outcome was a finding of no race discrimination. There were 417 findings of that in 2019. That represented 96% of the race discrimination cases filed in federal courts in 2019. Only 4% did the plaintiffs prevail in 2019. The second most common outcome was where there was a finding of no hostile work environment, where a hostile work environment was claimed either with regard to sex, race, national origin, or the like. So there were 434 findings where that was the case. 94% of those were decided in favor of the employer, and only 6% for the employees. In the most frequent outcome in 2019 was a finding of no retaliation. There was 995 instances of that. That's 93% of the time it was litigated in federal court, and only 7% of the time did the plaintiff prevail in that kind of case. So plaintiff wins, if we were to aggregate all the plaintiff wins together in 2019, you can see that 69% of them were under the FLSA, and the remainder were in all the other categories. So sometimes data gives us a very clear and unmistakable message, and in this case, that message is unpaid overtime or FLSA lawsuits are uniquely dangerous to employers. In order to avoid the prospect of a costly overtime lawsuit, workplace leaders may need to change the status quo, and they may need to do it quickly. Okay, well, let's talk a little bit about the collection of boxes that are shown here. This collection of boxes represent some of the most common mistakes made by employers that trigger FLSA lawsuits. First is interrupted meals. Okay, the FLSA generally does not require an employer to pay a non-exempt employee for a meal period. That's true in most states also with their state wage and hour laws. But under the FLSA, an employer does not have to pay for a meal period, providing three things are accomplished. One, the meal period lasts for at least 30 minutes. Two, the employee is completely relieved from his or her duties during the meal period. And the third is the employee is free to leave the duty post. So we believe that it's important for employers to have a strict policy prohibiting non-exempt employees from working during an unpaid meal period, including they should be prohibited from checking and responding to work-related emails, calls, and messages. And managers of non-exempt employees should be reminded to avoid contacting non-exempt employees during their meal periods, to avoid situations where the employees answer calls or respond to messages when they should not be working, when they should be, when they should not be working, because they should be taking their meal break. Okay. The second common problem for employers is improper deductions. Under the Fair Labor Standards Act, when deducting from a non-exempt employee's pay for uniforms, tools, or damages incurred by the loss or destruction of company property, the non-exempt employee's straight time pay after all these deductions, and when divided by the hours worked, must not be reduced below the statutory minimum wage. So in addition to the amount so deducted from that employee's pay, the deductions may not cut into any part of the overtime compensation due to the employee. So if the deduction cannot be made without either going below the minimum wage or without jeopardizing the overtime pay premium, then deductions have to be made over the course of multiple paychecks in a sufficiently small amounts to ensure the employee is at least earning minimum wage. Okay, so let's take a look at the third most common mistake, and that is failing to pay non-exempt employees for time spent before or after his or work shift doing something work related. For example, the time waiting for his or her computer to boot up. Booting violations generally occur when the employee clocks in by signing on to the computer network, but cannot log in for pay purposes until the computer has had time to boot up. In one case, over 2,600 customer service representatives working for Hilton Reservations Worldwide were awarded over $700,000 in minimum wage and overtime pay when the Department of Labor investigators found that the company failed to pay employees for work performed prior to logging in, such as booting up the computer, opening the program required to assist customers, and reading pertinent emails. So some best practices to consider to avoid booting up or shutting down claims could include, consider allowing an employee to manually report the hours as opposed to starting the clock when the employees log in or out, or consider having a designated employee come in early or stay late to boot up and shut down other employees' computers. All right, well, let's talk about briefly the fourth most common problem for employers that trigger collective actions under the FLSA, and that is misclassifying employees as being administratively exempt. The administrative exemption is perhaps the most difficult of the white-collar exemptions to understand and correctly apply. Typically, the administrative exemption applies to higher-level operational personnel who are involved in the development of policies and business strategies in their area of responsibility. The administrative exemption is not intended to be a clerical exemption and does generally not apply to employees engaged in rote, manual, routine, or recurrent, repetitive activities such as secretaries, data entry operators, and bookkeepers. The intricacies of the administrative exemption are kind of beyond the scope of today's presentation, but certainly investing time, including watching Ellen Kearns's presentation would be beneficial to you, certainly on issues like that. A fifth common mistake is not including bonus payments in the regular rate paid to non-exempt employees. In order to properly calculate overtime compensation employee must be paid, the employer must ascertain the employee's regular rate of pay for that work week. An employee's regular rate of pay is defined as all remuneration for employment paid to or on behalf of the employee, excluding certain specific payments, regardless of how an employee is paid, whether by the hour or by the piece, by the day, on a commission or salary, the employee's compensation must be converted into an hourly equivalent from which overtime rate can be calculated. Generally, all payments made to an employee for work performed should be included in the base calculation, unless there's a specific statutory exclusion. Again, these exclusions are beyond the scope of this presentation, but are definitely important to research when you have employees that are earning bonuses and potentially being paid for overtime work. Okay. Well, we've talked about one major area that needs to be scrutinized, and that's your pay practices. And that may offer the best return when it comes to employment law risk management. However, in a close second place is probably improving your organization's practices and documentation related to involuntary terminations. I once worked with an insurance company representative who described employment lawsuits as being car accidents that happen in slow motion. And what he meant by that was, at least in part, that you could see the accident coming. That is, you could see the involuntary termination on its way, and you could see the potential claim asserted by that person who was being terminated before it actually happened. So let me know in the comments if you agree with that description, that many employment disputes are, like car accidents in slow motions. Well, if it's true that employment disputes are predictable, one of the best things an employer can do is to control the timing of involuntary termination. And what do I mean by that? Well, if an employer establishes its expectations clearly, and then with patience and humanity, communicates with the employee when they fail to live up to those expectations, then any reasonable fact finder, like a judge or a jury, will likely conclude that an involuntary termination was inevitable. So when this slide here says that, set out the reasons before the termination, I mean well before. This can be done clearly and consistent. This can be done by clearly and consistently communicating expectations about how the employee is or is not performing up to these expectations. This can happen over a period of weeks, months, or even years. Then when you're setting out the reasons for termination just before termination, it's really just a simple summary that no one can disagree with. I like to say that an employment file should read like a long, boring story. By the time you reach the end should have been extremely predictable. Okay, so before your organization terminates an employee, make sure that the decision makers agree on the reasons prompting the termination. It's very, very rare that a single person in an organization makes the sole decision that an employee needs to be terminated. Usually there's somebody else involved in the decision, whether it's somebody who is asked to weigh in, whether it's somebody asked to approve. Usually there are multiple decision makers. And just know that your organization may be asked to explain the reason for the termination by multiple administrative agencies like the EEOC, Florida Commission on Human Relations, the Department of Economic Opportunity, and then if the case pursues to civil litigation, then a judge or jury is going to want to know what the reason for the termination was. There needs to be harmony and consistency when the various representatives from your organization are asked to explain the reason for the termination. Otherwise, it could be much easier for a plaintiff's attorney to punch holes in your organization's story and claim that the varying shifting explanations were concocted in a hurry to cover up for what they claim was some kind of prohibited discriminatory motive. So when it comes to documenting the termination, write out specific facts, avoid generalizations like wasn't a team player, and provide clear examples of failures by the employee. Okay. Facts don't need to be shared with the employee. All the facts that you write out don't need to be shared with the employee, but they do need to be documented. Okay. So there needs to be a clear termination plan before it's communicated to the employee. Background information should be provided. Facts supporting the decision certainly should be provided. And then a clear statement that the decision is final needs to be communicated to the employee. And this isn't a debate that you're having with the employee. You can listen to the employee, but don't argue with them. I mean, you're making the ultimate decision to involuntarily terminate them, so there's no need to debate the employee. And be clear about what the severance and benefits are and have those set out so you know that going into the termination meeting. When you go into the termination meeting, there should be more than just one of you. So decide who's going to keep notes, and the person who keeps notes excuse me, should note who attended, when the meeting started, when it ended, and precisely what was said. There should be documentation made about any return of company property. There should be documentation about any post-employment obligations the employee may have. There may be some kind of restrictive covenants that they would have agreed to as far as not calling on existing clients of the company. Have these documents ready for the review, including documents that have to do with their final pay, anything that addresses whether they'll be provided references and what their final benefits will be. In certain states, it's required that the company have a final paycheck ready. If that's not the case in Florida, but if you're in a state that does, make sure that you have that final paycheck ready. Okay. All right. Well, people in HR and legal departments sometimes refer to the legal requirements of the FMLA and the ADA as leave law, because leaves of absence from work are so common with employees who qualify for the FMLA and or the ADA. One of the most common and harmful problems I see in the leave law context is from a compliance area is poor communication. In a litigation setting, plaintiff's counsel can sometimes exploit an organization's communication failures. Honest mistakes by those tasked with leave-related responsibilities in an organization could be recast by the plaintiff's attorneys as being portrayed as that organization being uncaring. Okay, so how can you avoid that? Well, just assume the organization will be blamed for a breakdown in communication and take steps to prevent that from happening in the first place. Or in the alternative, prevent any reasonable person from assigning blame to the organization by being so strong with your communication. So essentially, you'll need to over-communicate, and during that process of over-communicating, demonstrate empathy towards employees who are usually having some kind of problem while they're on leave. Well, let's take an example from the FMLA. Depending on an organization's policy, employees taking a leave of absence, whether they under the FMLA or not, may be required to contact human resources at certain time intervals, perhaps every 15 days. Since it's somewhat unlikely that employees will remember to do this, it makes sense for an employer to adopt a practice of contacting the employee, let's say every 30 days, to inquire about the employee's status and intent to work. Employees should have been notified of their need to provide the employer with their periodic reports of their status back when they were provided with a notice of eligibility and rights and responsibilities form. That would have been provided early on in the FMLA process. While communicating with an employee regarding his or her intent to work, human resources should also discuss any return to work logistics with the employee, including, if applicable, whether they'll be required to have a fitness for duty certification form completed. Okay, so let's talk a little bit about employee handbooks. There's no legal requirement that your organization have an employee handbook. However, we know that what is likely the single most requested document by plaintiff's counsel during the discovery phase of an employment lawsuit. It's the employee handbook. When the discipline or discharge of an employee is challenged in litigation, an employer's most common defense is that the employee violated workplace policies. Where are those policies? In the employee handbook, or at least they should be. What is one piece of evidence in employment litigation that the company can completely control the content of? Again, that's the employee handbook. So if there was a trial regarding the value of the employee handbook, the points that I just discussed would be in our closing argument for why every company should review its employee handbook and take the necessary steps to make sure it's a useful tool in litigation avoidance. Policies contained in an employee handbook can be proved to be very solid documentation in a defense or an administrative charge or lawsuit. As laws continue to change and evolve, however, handbooks must also change and evolve as well. So take, for example, this gold circle pictured in the slide here. company policies, it's very typical for an employer to have company policies that are more generous than the law requires. However, it's important that the employee handbook have its company policies completely comply with legal requirements. If this legal requirement circle were to intersect company policies, but company policies didn't completely encompass them, that could be a problem. So in the case of no good deed goes unpunished, if your company policies are generous, but not all legal requirements are met, there could be a problem. So, all right. Okay, so in addition to policies, having managers and human resources professionals attend a training program on effective employment practices on at least an annual basis can be an effective way of reminding them about sound approaches to employment issues, which in turn helps protect the company from needless litigation. The training program can include an emphasis on key workplace policies, such as the policies against discrimination and harassment, so that the presentation of a program could directly contribute to the employee's ability to show a jury that the company places a high priority on the prevention and discrimination of harassment, and the company's ability to establish an affirmative defense to harassment liability. So a training program like this can be presented by employment counsel or other qualified presenters who can deliver the program in a way that's tailored to the company's business and its particular work policies. If the only thing that happens during this training is that the policies are read to a group, then the training may not be memorable. Let me tell you, it is embarrassing for a manager to be asked questions in a deposition about training that they were attended sometime in the last 3 years and to not be able to clearly communicate what they learned in that training. So please take the time to design a training session that delivers memorable content, even if the training takes longer to design or to present to the group. Essentially, you need to understand that education, basically needs to be entertaining in a way. It needs to be interactive. Otherwise, employees just aren't going to retain that information. And when you have important training, you want them to understand, when they walk away, what are the fundamentals that you wanted them to learn, and to essentially do whatever you need to do to make that memorable to the employees, so they'll be able to understand that training and understand that it was valuable. So anyway, I want to thank you for joining us today. It's been a pleasure to present to you, and next time I hope we're able to actually see each other in person.